Our last case set for argument is Wilmington Savings Fund Society versus Ronald Easley Jr. It is case number 28993. I don't mean to rush you, take your time.
Sorry, Your Honor. I apologize.
No problem. Both sides are present for argument, so each side will have 15 minutes to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. We have read the briefs and are prepared to proceed if you are. So, appellant, Ms. Reese, will you be reserving time?
Yes, Your Honor.
How long would you like?
As long as I can.
5 minutes?
Yes.
Okay. You may proceed.
Okay, Your Honor. I want to address the court. Thank you for hearing this case here. And I'll let you know, I don't have an attorney right now representing me. I admit I'm a little bit ignorant. I'm going to do my best to do this, but I don't have an attorney at this time. And if you need to know reasons why about that, I can explain that to you. But that was part of what happened here in this case, because this case had been to the court prior on appeal, and the court ruled that there was evidence that the party lacked standing due to the affidavits that were filed, and so the court sent it back to the trial court. In between that time, the judge that ruled on the case was no longer there, and a new judge took over. And another thing happened was that Greentree, the original plaintiff, substituted the plaintiff for a new plaintiff. And I think that's maybe the biggest part of the argument here, is that the court had already determined that there was a standing issue at the time that the case was filed. And by substituting the plaintiff, Greentree no longer appeared. They never it never answered counterclaims. This wasn't a merger, it was a substitution of plaintiff. It was a complete different entity. Wherefore, Wilmington could not answer for the allegations and the affidavits made by Greentree, since it's a completely different party, not the same entity whatsoever. And so those issues still remain that the trial court, that the appellate court held and remanded it back to the trial court. So that issue had never been resolved since the substitution of plaintiff occurred and Greentree no longer answered. The other issue here is the fact that how the loan was accelerated. It was the second. It was the second assignment of error in the first appeal that was ruled moot because you remanded it back to the trial court on the first review. So that is still, and I think now, right to look at as well, because it shows on the record that Greentree, when they did file this complaint, and this was the third foreclosure complaint filed on the Snowden mortgage. It had already been previously dismissed twice. I'm not even sure Greentree even had a right to file it for the third time, since it was dismissed twice already. And they sent the notice to cure, which is a part of the mortgage agreement. They sent that during the time when I was already in foreclosure with Bank of America on the same note and mortgage. When they sent the acceleration letter and the notice to cure. So that was something that was required as a precedent for foreclosure, which wasn't followed by Greentree. But again, they're no longer in this case, a party in this case, to answer to these things. So there's many issues that were raised in many motions that were filed, and there's issues that remain for trial, and I believe the trial court erred when they had a magistrate, it was an off-the-record magistrate pre-trial meeting, where my attorney had asked for a motion to withdraw 1 day prior to the pre-trial that both parties were required to attend. It was at that pre-trial, when I arrived at the pre-trial, that no, my attorney was not going to be there. In fact, the judge had not ruled on allowing my attorney to dismiss, to leave the case yet. So I was there in the pre-trial meeting with the magistrate, with the other party, with no attorney. And they said, "Is your attorney going to appear?" I said, "I don't know." And so they went, and I said, "I think there's a motion pending with the court right now," because I saw the day before she put in a motion to withdraw. So they went to the magistrate left the room, went and called the judge's office. The judge at that time then allowed the attorney to dismiss. After I'd already arrived, after I was already there, I objected to that front of the magistrate, said, I really want to reschedule this, I'm time to see counsel, I don't want to be here without an attorney representing me. She said, well, don't worry about that, all we're going to do right now is set the dates, we're just going to set dates on this, and that's all we'll do with this meeting. I said, okay. So, but it was at that meeting where the other party, they pulled out an alleged copy, alleged note that they alleged was the original note. To me, it looked no more than a copy you could pull off as a public record request at the Summit, in Summit County in the auditor's office there. So I didn't recognize that as being the original note. I didn't make any, affirm that as being it. I don't have a proper way to review it. I'm not a forensic document examiner. That would have been something that should have been presented at trial as evidence, not on the off-the-record magistrate's meeting. And somehow from that, the judge made the ruling from that meeting that somehow the note was produced, and I agreed to it, and somehow since that was shown that and it was endorsed in blank, that since they're the holder of the note, that they have right to foreclose. But I dispute that was the original note, number one, and number two, even if it was, that they still have to have standing in order to evoke the court's jurisdiction at the time they file the case, and not 2 years down the road, another party after 3 assignments now is holding the note, even if that was the original note. Because I think Schwarzwald was the one that said they must have standing at the time the case is filed, cannot be cured later to have the note. And plus the note has to be with the mortgage in order to foreclose anyways.
Can I ask you, how do you respond to Wilmington Savings' position that you didn't appeal the judgment of foreclosure, which was
Yes.
filed on March 15th? How do you
Yes,
respond to that?
yes,
You're saying
because-
the motion for summary judgment wasn't a final appealable order.
Yes,
You
because-
never objected,
Yeah,
never
yes.
filed an appeal to the final.
Okay, number one, I'm not sure about the law, how that works. It could have been my ignorance, because I didn't have an attorney at that time. But the reason I did that was because in the judge's order that I did appeal, it said in that order, this is a final appealable order. It's directly said that in the order. So that's, I took what the judge said to be true, and I appealed upon that, upon her stating in that order, this is a final appealable order. And it was the order for summary judgment that began this chain of effects. So since the judge had that written, that's why I appealed that order.
Did you appeal the decree of foreclosure as well?
No, it was my understanding that order was what I was to appeal, because the other one I didn't say about final appealable order. I don't remember it saying that. But I appealed the one that said this is a final appealable order, the one that granted summary judgment and denied all the other, all of our motions.
Okay, thank you.
Yes. And so I think that, I'll just go see if you have any other questions for me. I think I've said everything. Like I said, it was the third filing of the case, and I think the court's ruling on the first assignment of error, even in the first appeal, would still apply. It wasn't remedied or cured by the substitution. I mean, I'm just repeating myself. I mean, is there any other questions that you have?
All right, you'll have a full 5 minutes for rebuttal. Thank you. Counsel, you will have 15 minutes for your argument.
Good afternoon. May it please the court, Mr. Easley. My name is David DeMars. I'm here on behalf of the App.No, Wilmington Savings. I think the court, as the questions from Judge Schaefer has hit on an essential issue, one of the essential issues, and I think before you can decide any of the other issues, you first must tackle the issue of does this court have jurisdiction to hear the appeal? We believe that the answer is no. The case law in Ohio is pretty clear that you must appeal a final appealable order, and irrespective if the court makes a Scrivener's error and puts and trust me, I've been on the opposite side of this argument before, where you appeal the wrong judgment because the judge has put it is so ordered, or this is a final appealable order, but it leaves still issues to be decided. And in this case, there were issues to be decided. The court granted the motion for summary judgment. The court had not yet issued a decision with respect to what we were entitled to in terms of damages.
Yes, but it eventually did, correct?
It did on March 15th, and there was no appeal taken with respect to that. That would have
Was this
been,
appeal filed prior to March 15th?
it was. I believe
But
so.
doesn't the fact that the court put its final order on, upon doing so, make this a final, make the motion for summary judgment a final appealable order?
Not at all. I've seen countless courts, including this court, on its own jurisdiction, say we don't have authority at this point because there were still issues to be decided, and sui sponte, refer back to the court for a determination on other issues that have still left undecided. That, you know,
Specifically in a foreclosure case when the final,
yes,
I'm drawing a blank on the order.
yes, it is.
I mean, there was an order in this case setting forth the liens and distributing.
There was, that was the second, that was the 15th order.
No doubt that was a final appealable order.
I don't think there is any dispute that that was the final appealable order under which either party, should they have so desired, could have filed a notice of appeal.
Did the trial court have jurisdiction to enter that order after the appeal to the summary judgment order was filed?
Absolutely, because there was no final appealable order.
Well, the
The appeal was filed.
I would have to check, Your Honor, I don't want to speak up, and I could look as to when he filed this notice of appeal.
I think it was after the.
I think it was
final
after,
order.
now that I think it was after the May 15, or the 15th order, which we consider the final appealable
Yes.
order. And as you know, when you file your notice of appeal, you have to attach to it what you actually are appealing. And in this instance, it was the order of the 15th, or the 5th, not the 15th. So from a procedural standpoint, unlike the case before us, we're not trying to be overly technical with respect to that, but every court throughout the state of Ohio, and this court, including the Ohio Supreme Court, says there are certain ways and mandates certain ways in which you must appeal. And unfortunately, there are harsh results.
But are those cases where the appeal is taken prior to that final order?
Well, I don't know that the appeal was taken prior to the 15th order. I believe it was taken with respect to the 5th order, but not filed before the 15th order. So I don't think you get an opportunity to have a shotgun approach to appeals and say, well, we filed an appeal, so therefore it encompasses any order that may have been issued by the court. I mean, that is not what the rules prescribe. You be very specific with respect to what you must appeal. And I think our point with respect to this is there was no appeal of the 15th order. There wasn't.
Well, it comes down to whether or not the fact that the appeal was filed after the court's final appealable order makes the summary judgment ruling a final appealable order. That's what it comes down to.
Well, and that obviously, we disagree. We believe that it was incumbent upon the appellant, and unfortunately.
Well, let's just assume for argument's sake that that's true. How did the court err here?
We don't believe the court erred here.
I mean, what's your argument as to?
With respect to the merits of the
Yeah,
case.
that's right.
Right, yes. I mean, this matter's been dragging on now since 2010. There's been no payments made on this mortgage for almost 9 years. We've had numerous attempts at resolution. We've had, since this court issued its decision in 2016, we've had multiple bankruptcies filed by the appellant that have, on the last one, the court dismissed it on its own and barred the appellant from filing a complaint or filing a bankruptcy for 180 days so that the lender could proceed with foreclosure, because every time we get up to the date of a foreclosure sale, a bankruptcy was filed. My client has expended countless tens of thousands of dollars, not to mention the money it hasn't been paid over the life of this loan. And we're talking 30% of this mortgage is delinquent, just in terms of payments. This is a 30-year mortgage. Payments haven't been made in 9 years. And in terms of, and at some point in time, equity becomes an issue. And we're not saying that that's the only reason this appeal should be denied, but it sure should be a factor, that the appellant has used every means possible. And to stand before this court and say, well, I don't have a lawyer. You had a lawyer. Your lawyer, I'm not in any way stepping into the shoes of why that lawyer recused himself or asked to withdraw from something, but they withdrew from the case. They had an opportunity to get another lawyer.
Can you talk about the affidavits, for instance?
Certainly.
Why they were sufficient in this case?
Well, they check all the boxes. They check all the boxes. They're based on personal knowledge. The people reviewed them. They saw the documents. They were familiar with what they needed to do. As this court is aware, previously that was the issue that was presented to this court. There was an allegation that the affidavit that was provided by Ms. Kesner was deficient. Didn't check the boxes, and I'm sure, again, as this court is aware, have you done the conditions proceedings to being able to foreclose or being able to move forward with a motion for summary judgment and the affidavit? That's been a moving target for many years. And this court has finally come down and said, hey, you have to check all these boxes in order for us to consider the affidavit sufficient for you to be entitled to summary judgment. This court determined in the 2015 appeal that affidavit by Ms. Kesner didn't check the boxes. In this instance, and for instance, did she see the note? Was she familiar with the loan? Was it something she was responsible for? So taking the guidance from this court, when the case was remanded, we provided 2 affidavits to the trial court in support of our motion for summary judgment, which we believe corrected any errors that this court determined needed to be proven to support a motion for summary judgment. Not to mention the fact that there was an issue about whether we were in possession of the original note.
Those would have been the affidavits of Bennett and Steinberg?
Yes, Mr. Bennett and Mr. Steinberg.
Did Mr. Easley challenge those?
He does not. There was no challenge to anything with respect to that. Mr. Easley was unrepresented, I believe, at that time. But furthermore, as this court is aware, is the appellant's brief, in this case, is the identical brief. I didn't go word for word, but the identical brief that was previously provided in the, in the prior appeal, where it challenges the affidavit of Ms. Kesner. Ms. Kesner did not provide an affidavit that this court, that the trial court relied upon in determining the summary judgment.
So your argument is if Bennett and Steinberg's affidavits meet this court's prior precedent as far as what they should say, trial court should be affirmed.
That is exactly correct. That is, in a nutshell, that's it. And not to mention, we went one step further. We brought the original note to the hearing, presented it to the court for the court's consideration. If counsel was there, it would have been presented to counsel for his or her consideration.
So is that part of the record as well? Copy of the note, I'm assuming?
Yes, the copy of notes attached to the complaint.
Well, what import is it if you bring the original to a status conference and show it to someone?
Well, you want my, well, of course you want my.
Well, the trial court seems to rely on that.
Yes. From a historical perspective, a lot of times in a foreclosure case, and I'm sure everyone on this panel, all 3 judges on this panel have seen this issue, is how do we know? You know, that's what the appellants will argue, or the defendants in a foreclosure. How do we know that you were actually in possession of the foreclosure, or the original note? And about $1 for every attorney that sent a letter to, we want to inspect the note, and we have a safe in our office, and we put all of the original files in there. If somebody wants to see the original mortgage or the original note, we make it available to them. But I would conversely say that that probably happens about 5% of the time, that they say, we'd like to see it. I tell them, hey, it's available for inspection. You're welcome to see it. We'll bring it to court with whatever it is you want. And they, oh, okay. Then you kind of, I think it was another box, in answer to you, Judge's question, I think it was another box to check. Have you done this? You've checked off the boxes with respect to what the Court of Appeals is requiring be contained within an affidavit to support a motion for summary judgment. Check, check, check. What about the note? Let's try to cover all of our bases here. Do you actually have a copy of the note? I said, make sure we take it to court with us so that if anybody requests to see a copy of the note, it can be inspected, it can be presented to the court. I think that is the significance of that we could also go above and beyond that, because it hasn't been challenged. It's not been challenged at the hearing. It wasn't challenged in opposition to the summary judgment that's before the court for consideration. It is not challenged in the brief that's been filed with the court. There has been no challenge to it. There is nobody here to say, or there's no evidence before this court that says that note is deficient and here's the reason why. In all of my years, and I've been doing this for 25 years, I've had one expert ever ask to see somebody say, hey, we want to give this note to our expert, see if your ink was correctly blue. That's it.
But perhaps that's because it's not relevant.
Well,
Because the requirement is that they have it at the time of filing the complaint, not thereafter. At bearer paper, it becomes a rather insane type of inquiry, right?
yes, yes. As we first learned in
Negotiable instruments.
negotiable instruments when I was a teenage boy watching an Eddie Murphy movie, about bearer paper. But I agree with you. I don't find it to be as relevant with respect to the issues in the case, other than being able to demonstrate that you have it. That's not the standard. The standard says, did you have it at the time, were you in possession of the note at the time you filed the complaint? If you were, and somebody can say that, you've met the threshold. Because anybody could get it afterwards, and that was kind of not going on a history lesson, but that was kind of what created the whole foreclosure issues and decisions, was you were signing stuff that you weren't really in possession of. So,
Well, there's a difference between being in possession and being the holder.
Correct.
Okay.
correct, at 100% agree. So we believe that, first of all, this court never gets to the merits of the case, because from a procedural standpoint, we do not believe this matter is properly before the court, because there was no there's been no appeal of the final appealable order. Secondly, even if you were able to get over that hurdle, we believe that there's been no challenge to the issues that were presented to the court with respect to the decision on summary judgment, that there's been no challenge to the affidavit, the evidence, the court's decisions, other than a duplicitous brief that was filed in a prior appeal that has absolutely nothing to do with this case.
Well, I think, I know your time is running short, but as I understand the appellant's argument, it is, that issue was never resolved. And so all those same issues present themselves in this appeal, and whatever happened at the trial court level may or may not be dispositive after remand.
If I may, I disagree with the argument, not the statement made by the court as to what the interpretation is of this argument. I think the court carefully considered what this court directed the judge to do on remand, and said, you need to look at these and make sure that these boxes are all checked before, not only the judge in this case, but any other judge sitting in the 9th District. These are the standards that we expect to be met. This court determined, the trial court determined, that they did. And there was no challenge to that, and that's why summary judgment was granted. And for the reasons stated in my argument, I would ask that on behalf of my client that this court affirm the trial court's decision granting summary judgment. And thank you.
All right, thank you. You have 5 minutes for rebuttal, sir.
I'm sorry, sir. That's my pen, oh, green pen, thank you. Can I have just a second, Your Honor?
Sure.
My time card, just to make a quick note.
Yeah.
Okay, Your Honor.
Okay, 5 minutes.
Okay. I just want to say this, Your Honor, and to the other party. I've owned the property for 27 years, and I think your current client now has, this current assignment they've had it for about 16 months. And they took this new assignment, knowing that it was a foreclosure, knowing that there was 2 previous foreclosures, that there may not be any equity in this case. So this idea that I'm causing some sort of a problem by appealing this case, I don't think is right, because like I said, I've been there 27 years, and the new supposed alleged owner of the note mortgage has only had it for 16 months, and it's some sort of a pass back trust security. I signed a note with Countrywide Mortgage, who the other party does not represent. It was then transferred to BAC Home Loans. It's evident that Countrywide, BAC Home Loan, numerous cases of fraud and robo-signing, and then the mirrors, the problems with mirrors and recording. These types of issues, these are very important when it comes to foreclosing and taking a person's property. There's specific things that have to be met, have to be done for a client to come into court and to claim after 8 assignments down the road that they're now the one that's going to take your property from you and demand you pay back $150,000 on an original note that was only $80,000 in the beginning, which was like 15 years ago. But aside, so I think I do have a legitimate reason to bring this appeal contrary to what the other party is saying. So with all the fraud and with all the third foreclosure on this case, because the last one actually had an assignment of the assignment of mortgage was actually signed by an employee of the law firm, Carlisle Law Firm, that was actually bringing the case. It was one of their employees that signed as a vice president of MERS to assign the mortgage to them before they went into foreclosure on the case. So that brings into issues all kind of breaking of the chain and unclean hands on the part of this party. But to get back to the crux of some things that were said, the second affidavit that was presented, the other party acts as if when the substitution of plaintiff happened, Green Tree never responded from that point on. They were not party to the case. So if they weren't party to the case, anything that happened after that, with this new entity now claiming it's now taking substitution, it wasn't a merger. The Green Tree merged with Ditech, that's different. They're the same company, same entity. But a substitution of plaintiff in this case brought a whole new entity into this, and they cannot remedy and answer for things that Green Tree did. Many of the counterclaims and the arguments were made against Green Tree, who is the one who filed this case. And so, but however, the second affidavit that was presented was also challenged at the trial court level, because the actual affidavit actually admitted that Green Tree didn't own the note at the time that the case was filed. In the sworn affidavit, it actually acknowledged that they had been in possession of it. I believe it was almost 6 months, 7 months prior to when Green Tree filed the case. So even that affidavit was defective. But I would argue that the fact still remains. Nothing was resolved from the first appeal. They still remain. They were not remedied anywhere in the trial court. So They still remain. I think the second issue is right to be looked at, that was in the first appeal, but also is there again on the second appeal, and that is whether or not Green Tree properly accelerated this note, gave me the right to cure while I was in foreclosure with Bank of America. But again, Green Tree is not there to answer that. This new entity is not going to be able to answer for what Green Tree did or did not do. And then the last thing I'll address then is this issue that somehow I didn't file my appeal correctly. I went from what the judges said in the judge's order. I took that to be correct because it said it on the order. I did file the case prior to the 15th, so it did incorporate the other judgment entry into that, because I filed it after that. But I filed it because the judge's order said that. So, I mean, to me, if that's not correct, I think the judge's order would be defective on that basis, because no other reasonable mind, especially if an attorney, would know if that says final appealable order, that's the final appealable order. So I believe that's all I have, unless there's any other questions from the court.
Questions? All right, thank you both for your arguments. The court will take the matter under advisement, issue a decision in due course, and each of you will receive a copy of the decision on the day it's released from the clerk of courts. The opinions are also posted, I should note, on the Ohio Supreme Court's website. Court will be adjourned for